Hello, everyone. Hello, Michael. I've got Michael Wynn with me today, a lawyer of Dunedin and one of the partners at Wilkinson Rodgers, a local firm here in Dunedin. And Michael's helping us with some common legal issues that we come up against all the time when we're giving financial planning advice to people. And the topic today is family trusts. Things have changed a bit over the years. Michael, can you bring us up to date with family trusts?
Hi, Rhodes. Well, in June last year, government passed a new act called the Trust Act 2019 that comes into force January next year. So this replaces the 1956 Act that we're still currently working under. So it's well due for a revamp. So the new act, when it comes in, will make a considerable number of changes, most of which are pretty mechanical things that wouldn't worry anyone. There's one or two things that are reasonably controversial for some people, and it makes a number of changes. For example, a trust can now run for 125 years. Previously, it was 80 maximum. So that takes into account that people are living longer. And it also clearly now is 2 generations, whereas previously 80 years was never 2 full generations.
Oh, I see.
So very handy for the farming community because it's a common use to have the farm land in a trust, so it covers more than 1 generation.
And does that happen automatically, Michael?
No, it doesn't. You would have to vary your trust deed. So you need a power in the trust deed to do it, a power to vary the terms. And there is no ability under the current Trustee Act to do that. So it has to be in the deed. Yeah.
And so any stage after January of next year, trustees will be able to, if they have the power to vary, they'll be able to extend the life of the trust through to 125 years.
Yes, you do. There's several other changes you would probably want to be making as well. I mean, it's a matter of reviewing the trust deed as it is now and seeing what things do we need to change to bring it up to date.
It's like bringing a will up to date.
Exactly, yes. So as long as there's a power to vary it, then you're okay. If there's not, then you can't fix it and you have to look for another solution. But you'd want to be doing this before the Act comes in.
Oh, you do it before the Act.
So you can make it effective. You can make it effective from 30 January 2021.
Ah, right.
Yes. So it pays to people should be from now on reviewing their trust deeds with their lawyer just to see whether just have a review. Yes, some of the other issues it raises is drop the age at which someone can inherit and at which someone can be hold a position in the trust like a trustee from 20 to 18. So 18-year-olds can now receive distributions from a trust and they can be a trustee.
Yep.
Which seems a bit young for me, but anyway.
What other changes are there, Michael?
Right, quite a number, but as I said, most of them are just sort of governance type things. But one of the biggies that is reasonably controversial is that the trustees will be required to write to all beneficiaries of the trust, telling them that they are beneficiaries and they are entitled to ask for information. So they've got to be supplied. If they request, they've got to be supplied with some basic stuff like the copy of the trust deed and who the current trustees are, and a copy of any changes in the trustees. They can also request other information, but the trustees have the right to refuse it. And in the Act, it sets out some of the parameters for that that the trustees can consider. For example, if the trust owned shares in a family-owned company, you could say, look, I'm not giving you the company accounts because it's commercially sensitive. Or you could say, if a younger beneficiary wants financial information, you could say, no, we're going to refuse that, and that we want to encourage your self-reliance and independence, and we feel that this will be harmful. So you don't want children thinking they've got a sense of entitlement. And there's a range of them. There's about 11 or 12 things that you can refuse it under. So it's not the end of the world. And the other thing you can do, if you've got that power to vary the terms of your trust, is you can actually contract out of that provision a little bit. You can water it down and say, look, information other than the trust deed, etc., that I mentioned before, anything other than that can only be given to mum and dad.
Right, because I can imagine trustees writing to beneficiaries, and some of them are babies.
Yes.
Would mum
Exactly.
and dad then intercede?
Yeah, yes. Yeah. So a lot of these changes came about after the Panama Papers episode. You may remember
Yes.
years ago, where the rest of the world said that our trust regime wasn't very transparent.
Yes.
That we were hiding, foreign nationals were putting their money in trust in New Zealand and hiding it. So
yes,
a lot of these to create that sense of transparency, whether it does or not, because people will just get around it anyway.
Yeah.
Yeah. So
any other changes that people with existing wills should be aware of, Michael?
Existing trusts, yes.
Yeah.
Yeah. So you really need to bring your trust deed up to date. But one of the things was you might want to change how long the trust can run.
Yeah.
And that will be a personal decision. In fact, we don't really see that many trusts ever run 80 years. So, most people probably won't change it to the 125, but you can if you want. There's also some of the mechanical provisions that they can bring in. You might want to water down some of the investment provisions, so that, if someone wants to put in some of their existing investments into a trust, that's allowed, where they may not be considered authorised trustee investments. So those sort of issues, you've got to make sure that your trust deed fixes that rather than rely on what's in the Act.
Yep. Michael, is it any more likely that people are going to want to have a trust now that haven't already got one, or is it less likely? What's the trend in terms of the uptake of family trust and the usefulness?
Yes. Well, certainly once upon a time, every man and his next door neighbour had a trust which owned their house, and that was about all. And you only had it because your neighbour had one, or your friend down the road.
And rest home subsidies were
around rest home subsidies, but that's changed. That's gone now. There's no way you're going to protect yourself, protect your assets from being counted in a rest home subsidy asset test application. So forget about that. So a lot of those trusts, which are really just the one asset, the house, are being wound up because they're really of no use, and it's just a bit of a pain for the people to administer. So they're gone. A lot of people who once had a valid reason for a trust, they may have been self-employed in business, wanted that asset protection, but now they've sold the business and retired. You've got to weigh up whether you want the hassle of administering a trust, because it does become a bit more onerous from next year. So we'll probably be winding up a few of those. But certainly there's still a demand for trust. I'm still getting lots of inquiry, particularly through COVID, with people questioning their own mortality, and also questioning how protected is my business. So anyone that's self-employed should really seriously consider having a trust.
Yeah.
Some of the other common uses are where people have children with special needs, they may have disabilities or something that need that financial support once mum and dad have died. So there's providing a nest egg for inheritance for those children to be managed for their benefit. And another common one that people wouldn't probably realise how common it is where families become estranged. So I mentioned when we talked about wills earlier that I've seen a number of cases where someone has a family early and then they divorce and then they never see the child again for 40 years. Well, of course, you owe a moral obligation in your will to provide for those children. or they can attack your estate. So to get around it, if you feel you don't have that moral obligation, even though the law says you do, then you put your assets into the trust and make sure that those children are not a beneficiary, because they can't make a claim against the trust, but they can against your estate.
So there's no anti-avoidance provisions there?
No, there's not. So it's really, that's one of the, you'd be surprised how often that happens. So that's another valid reason. But apart from that, no one's doing them just to own the family home anymore, just because for the sake of having a trust. Those days are gone.
Well, you mentioned if you're in business, there's perhaps a need for a family trust. Why is that, Michael?
Yes. Just protects the assets from any creditor risk you may have.
What assets?
Apart from the bank, well, whatever assets you put into the trust. Generally, your family home.
Your personal assets.
Personal assets.
Keep them separate from the business.
Yes, so your personal assets should be in a trust, and therefore if you've done it right and not given any personal guarantees, or the trust hasn't guaranteed anything, then they should be safe. If the business had a claim against it or the person was sued,
yes,
it should be safe.
Yeah.
But you can never protect them from the bank, unfortunately.
No. Okay. Yeah. All right, Michael. Well, thank you for that. Is anything finally sort of overall you would say about the changes coming up in the next 6 to 7 months?
Yes, I'd say, look, don't be scared. There's a lot of scaremongering out there by some people saying that's the be all and end all, the end of trusts, and it's going to be so onerous that no one will want one. Well, it's not right, because a lot of these changes were already having to be abided by anyway. Just
the law, and the law.
So it's just bringing it more into focus. So don't be scared off. If you've got a valid reason still to have your trust, look, go and see your lawyer. Make sure your deed's brought up to date.
Yeah.
And if you're not sure, then consider your options. Should you still keep it or not? So you have that discussion.
Thank you very much, Michael. We'll end it there. I really appreciate the time you've given us, and a good night, everyone. Thank you, Michael.
Thanks, Rhodes.